The Consumer Product Safety Commission was created by Congress 50 years ago, but 5 decades later, the agency often can't alert the public about dangerous products. Now Congress is trying to change that. The mission of the Consumer Product Safety Commission is straightforward: protecting the public from unreasonable risks of injury or death associated with the use of thousands of types of consumer products. But there's always been a straitjacket on the federal agency, preventing the CPSC from recalling a product on its own or even warning the public about potentially deadly product defects. That straitjacket is a provision in the Consumer Product Safety Act, known as Section 6B.
Section 6B is a part of the law which says that a manufacturer can negotiate with the Consumer Product Safety Commission before there's a warning. So it aids that manufacturer, even when the product is defective, in hiding the hazard from the public, because they can negotiate when, how, even whether it is disclosed.
Connecticut Senator Richard Blumenthal is trying to address this defect in the law, introducing the Sunshine and Product Safety Act, which would repeal Section 6B. What would this particular piece of legislation actually do, and how would that help consumers?
The Sunshine and Product Safety Act would literally enable the Commission to shine sunlight on defects, enable the public to know, and issue more effective warnings and recalls without giving the industry or the manufacturer a virtual veto over how and when and even whether there is disclosure.
Blumenthal is hoping for, but has not yet received any bipartisan support for his legislation, blaming what he calls the armies of lawyers and lobbyists working against his proposal. Meanwhile, over on the House side of the Capitol, Congresswoman Jan Schakowsky, the chair of the Consumer Protection Subcommittee, has introduced a companion bill aimed at empowering the CPSC.
The laws often have been set that really prefer the manufacturers, the business community over consumers. And that's a real sad comment. And so it's time to put consumers in charge, the paying public, after all, people buy these products, to be assured that they're going to be told if there's a danger.
Schakowsky says companies often do a cost-benefit analysis before recalling a dangerous product.
Oh, I mean, there's absolute profit because of the delay. They can continue to sell products. And in fact, even after it is known by the CPSC itself, if that information can get out to consumers, we know that there have been deaths as a consequence. That is the consequence. Children can die.
What compelled Schakowsky and Blumenthal to act now is the powerlessness of the CPSC to order a recall of products such as Fisher-Price's Rock and Play Sleeper, an incline sleeper that defied American Academy of Pediatrics guidelines for safe sleep. Ultimately, nearly 100 infants died in the product. 6B gives companies the authority to prevent the CPSC from issuing a public warning. In the case of Fisher-Price, the agency knew as early as 2012 that babies died or were injured in the sleeper, but there was no recall until the company agreed in 2019. Representatives from both parties grilled company executives during a House hearing last April about their failure to act.
How many children have died totally in this toy or whatever? How many total died?
Today, we are aware of approximately, I believe it is the number is currently 97.
Fisher-Price admitted here today for the first time, 97 infants died in the Rock and Play. That is nearly twice the number of deaths previously reported, and it's nearly 7 times the number that Fisher-Price admitted to CPSC in 2018.
The sponsors of the Sunshine and Product Safety Act say they're trying to get their Republican colleagues to support the legislation and pass a bill before the midterm elections, arguing that empowering the CPSC will protect more Americans from future untold dangers.
We don't need to see any more injuries and deaths in this country that are preventable.
In Washington, I'm John Decker.